Good morning. My name is Don Michaelman, and I want to welcome you to the October 27th, 2022 public hearing of the City of Prescott Planning Commission. I'd like to welcome Councilmember Tenney for attending here. This is an open hearing and is being tape recorded and videotaped by the city. Proceedings are being televised by representatives of the public media, the public, local cable and/or radio stations, and may be rebroadcast. The number of commission members present is 7. We have 6 here and 1 on Zoom, and it requires a majority vote of those present to pass a motion. As some individuals may be attending this meeting remotely, all parties wishing to be heard, including commission members, are required to state their name prior to speaking in order to ensure accurate minutes. Members of the public, when called upon, are required to state their name and address for the record so that we may know who is speaking and be able to contact them at a later date if necessary. I would also request that you check your cell phone, make sure it's either off or on mute. Would appreciate that. Staff members will introduce themselves when they speak. Before we start, well, let's have introductions of the commission members. Stan, would you start? Stan's on Zoom.
Thank you.
Stan Goligoski.
All right. Susan?
Good morning, Susan Graham.
Good morning. Nice to see you all again. Tom Hutchison.
Ted Gambogi. Butch Tracy.
Tom Riley.
Okay.
I'd like to say it's nice to see everybody again, but this is getting old.
So before we start, this meeting is going to be basically for the commission members to discuss and review information that's been presented. We ended the last meeting with the public hearing still in progress. We will continue that public hearing for up to 30 minutes on it and request that each participant who comes up to speak limit their time to 3 minutes, and we will not be able to transfer your 3 minutes to someone else. Each person will get 3 minutes on that, okay? And Kaylee will keep track of that for us. Did you know that, Kaylee?
Now I do.
Okay.
Yeah. I'm ready.
First item on the agenda is the review of the minutes from the October 13th, 2022 meeting. Are there any corrections? If no correction, is there a motion?
So moved. Tom Riley and Butch Tracy.
We have a motion and seconded. Any further discussion? If not, Kaylee, will you call the roll?
Stan Goligoski,
Approved.
Susan Graham,
Approve.
Thomas Hutchison,
Approve?
Tom Riley,
Approve.
Butch Tracy,
Approved.
Ted Gambogi,
Approved.
Don Michaelman.
Approve.
Motion passes unanimously.
Okay, we're going to open it up for the public comments on this. I would like to start off with persons who have not had an opportunity to speak before the commission before and give them an opportunity first, and then we'll go down the list of people who want to speak. And again, please keep it to 3 minutes, and we would prefer that it be new information to us, not necessarily something that's been presented before on that. Do we have anybody who has not presented before the commission? All right, I'm going to point there. Gentleman back here raised his hand first, then we'll go with you, sir. Come on down, sir.
Ma'am, you have my request there, too.
Okay. Thank you.
I'm Ronald Lehman.
If you could bring the microphone up to you there. Thank you.
Hello,
Here.
I'm Ronald Lehman. I'm a resident of Saddlewood. Are there any Saddlewood and Westwood people here?
Yes.
Okay, all taxpayers, right?
Yes.
Good.
Do you really expect them to say they're not a taxpayer?
We have Congress people and people running for Congress that haven't paid their taxes.
Congressional people in the audience.
Thank goodness.
I want to make a general comment, and then I'll read a one-page letter that I have here. I know there are issues beyond my comprehension and my knowledge that you all are looking at in terms of liabilities and responsibilities to the public and to passengers on planes and residents or people working in businesses. And I applaud you for that. But at the basis of all you do, please remember that there are contracts in place that were made in good faith, either to buy a home or to buy property or to start a business or whatever, and that we keep those in mind before we get too far involved in what's in the future, because we can't walk on the people that have already made a financial commitment and so on. Thank you for that. As a concerned citizen of Prescott, I have 2 financial investments which are at stake as the committee moves forward to make recommendations to the City Council for rezoning areas around the Prescott Airport. My wife and I bought a lot and built a home in Saddlewood. And we have lived there for close to 2 years. Additionally, our church has contracted with Mr. James to purchase acreage to build a church, as our congregation has grown to where we hold currently 3 Sunday morning worship services to accommodate the community. If I may, I would like to discuss the issue of our choice of residence and the church building site separately. My wife and I undertook a search for a community in which to build our retirement home, taking more than 2 years to settle on Arizona and the Prescott Valley area for that home. We made a down payment on a lot in a subdivision, and were given the weekend to change our mind. Subsequently, we looked at Saddlewood development, which we had somehow missed, and there we found a floor plan more to our liking than the previous floor plan and withdrew our deposit on the original lot. Now, almost 3 years later, we have discovered that the frequency of airplanes, apparently attributed to flight schools, is irritating due to the noise, but mostly to the frequency of their flights. Yesterday, our homeowners association held business meeting outside in one of our park areas, and we struggled to hear the speakers and ourselves due to the noise of the flights. My wife and I signed paperwork when we bought the lot prior to building our home, and we were notified we were close to an airport and there would be subsequently noise issues. We also realized the traffic noise from Willow Creek and Highway 89 might be high at times. The many ambulance sirens and those of emergency vehicles are also somewhat are things that we have to endure. We have learned to accept these drawbacks to where we live, and as long as the jet traffic does not increase, we can live with the Forest Service fire tanker planes that shake our houses from time to time because we want the fire protection for our greater communities. Now to the church issue. We as a church body welcome the acreage offered by Mr. James because we knew it would allow our services to be offered to a greater portion of the community, including the growing northern Prescott community. We discussed with governmental entities the need and cost of entry and exits to city streets not yet developed for the church complex areas, as well as drainage requirements and fire removal and maintenance of vegetation associated with the property. The church made a down payment for the property with a balance due at the end of this year, and we entered into contract for the property. Robin told me personally that unless we place a large portion of our church structure underground, We would not be allowed to build on our own property. She is not the final authority in this matter, although she believes she is. Now we understand that 3 to 4 other churches have been retroactively notified about this ABO, and they will not be able to build or expand. Some of these churches have owned their properties for a long period of time. Is this an attack on religion by the city of Prescott? I hope not. In conclusion, I ask that the committee to include in their recommendation to the city council a future date for this redistricting, I'll put it that way. And in some way, say that future building permits, not going backwards on building permits, but future building permits will be restricted. This will allow the hospital, other businesses and entities who already have owned their property or who are under contract to proceed. I don't know the ins and outs of how you do that, but somehow the people that already have contracts and financial obligations should be allowed to continue before the new law or ordinance goes into effect. If a document announcing the potential hazards to build on their property, such as airplane noise, possibility of an airplane crash, or brush or forest fire from a wilderness area adjoining their property, needs to be signed, so be it. And if they aren't willing to sign that, well, then they can't move forward. That's understandable. But to retroactively restrict companies or businesses from building on their own property is wrong, if not illegal. Thank you.
Thank you, sir. Before we continue, I intentionally let the gentleman have more than 3 minutes. This was his first time speaking before us, and I think he deserved the opportunity to present his full thoughts. Future presenters coming up here would like you to keep the 3-minute time limit in mind, okay? Sir, I think you raised your hand.
Yes.
Come up, sir.
My name is Lionel Jaguar, and I'm with Saddlewood. My address is 1381 Warbler Way. And in 2012, we bought a condo up here at Tanglewood Hills. My wife and me, our dream was to move up here. We lived in Phoenix for 50 years, and I wanted to try it out and see how she's going to accommodate. Now, we didn't live up here all year long, but she loved Prescott because of all the activities, everything else. When we signed the contract with Saddlewood, okay, we said, wow, we got our dream house, okay? I worked since I was 12 years old. I had 3 paper routes, LA Times. I worked my entire life, okay, to get up here once we moved to Arizona to live up here. And now I have 1 child. I got 2 grandchildren, okay? You're going to change the zoning on it. I know it's not concrete, but you're going to change the zoning on it. All the money I worked my entire life, you're going to change, if you change the zoning on our property, it's going to lower the property value, okay? I'm not from a poor family, but my parents worked 2 jobs, so I can go to Catholic grade school and Catholic high school. And what you're doing to us is just, there's so many senior citizens that live in our development, and they have grandkids and all that. And I know you have grandkids and children. The thing is, you know, we were brought up in a different world, different time in the 50s. And most of the people in our development are here to, you know, give more back to your kids and grandkids than what you had. And what you're doing, if you are doing it to our community, is just a really detriment. I know I never complained at all, okay? But I met the first time with Robin at the airport, okay? And the reason I went to the airport, because a Embry-Riddle graduate, okay, flew in to the airport on an either F-16 or whatever it was, okay? Came over to my house, and he was trying to brag to his friends. We were gone that day. All my neighbors came over because they know we have 2 little chihuahuas, okay? And he didn't land on our grass area, but he took off and went straight up, okay? I told Robin about it, and it was like, well, big deal. What do you mean big deal? You know, I have 2 little chihuahuas. My oldest chihuahua is 16 years old, and she just, you know, peed everywhere in the house. I never complained her now, said nothing to the HOA or whatever. But what you're doing, if you are doing to us, is a detriment, okay? Because this is our livelihood. And like I said, this is our dream house, and we lived there for 2.5 years. And I want to thank you for giving me the opportunity to speak with you. God bless you all, and have a great day.
Thank you, sir.
Thank you.
Any other persons who have not spoken before us before? If not, Kaylee McCall, and since now we'll be dealing with persons who have presented to us before, Kaylee will do a 3-minute warning on that, okay? First?
Sure. I just want to clarify, I got a comment card from TK Morand, and would you like me to read it into the record? Sure. Okay. TK Morand at 1420 Amethyst Lane. I do not support this AVO in its current form and believe it should not pass at this time. Please do not forward this to the council at this time. Okay. So we have Stephen Polk.
May I connect? Thank you.
Okay.
Mr. Chairman, Commissioners, my name is Stephen Polk, attorney for James Deepwell Ranch. Now, I urge you today to vote no on the AVO. It's not needed. It's not consistent with our community's values. It's governmental overreach. It's a moving target. There's new information every time. It keeps changing. So vote no on the AVO. Now, Deepwell Ranch has a contract with the city. It's called the Development Agreement and the Master Plan. And the contract prohibits the city from changing the zoning unless there is a change in state or federal law that makes a zoning change necessary. Now, I will tell you, there has been no change in state or federal law that makes this necessary. And to be clear, the city does not have Deepwell's consent to change the zoning. So if you do this, it will be a breach of the contract, it will be a breach of the state constitution, and it will be a breach of the federal constitution. This will be a condemnation, plain and simple. Do not do it. Do not be a party to this condemnation. Now, it's important for you to know that the Deepwell Ranch Master Plan complies with the 2015 General Plan and the 2017 Airport Specific Area Plan. It also complies with FAA guidance. I'm going to show you one slide. All right, just run a quick Google search, FAA land use compatibility. The first website that comes up, FAA.gov, compatible land use. Guidance. The first link is about extraction of oil. That's not us. Second link, land use compatibility in airports, a guide for effective land use planning. This is what they have right on their website when you Google this. Go to page 52, land use noise sensitivity matrix. What the FAA guidance tells us here is that residential is appropriate all the way to the 65 DNL. In fact, every use for land is appropriate up to 65 DNL. What you can conclude from this is don't regulate, don't prohibit uses outside of the 65. You don't have to go to the 55. You don't have to go to the 60. That's the guidance I just showed you on the FAA website. Now, there has been no evidence presented to you that this AVO is necessary. And if you recall, in the Deep Well Ranch Master Plan, we already have an airport noise overlay. So what I'm showing you today is this is consistent. Last point, remember, the City Attorney Joseph Young told you at the last meeting that one option for this AVO is to exempt the Deep Well Ranch Master Plan in its entirety and exempt all of these homeowners in its entirety. So vote no on the AVO, or if you have to vote yes on something, vote only on the condition that the Deep Well Ranch Master Plan is exempt in its entirety. Thank you, Commissioners.
Thank you. Please. I request that the audience respect speakers and the commission members and not have displays in the public. And we've asked this before, and it's only being respectful. Thank you. Next.
Mr. Chairman, can I ask Mr. Polk a question?
Sure.
Thanks for doing all the homework. Good job. You say that the city can't break the development agreement for any reason. Yet I recall reading in that development agreement that safety is one of those exceptions. Is that true?
Great question, Commissioner Hutchinson. What it says is that the governing rules, and that is state law, federal law, building regulations, even the zoning code. If there's a future change in state or federal law having to do with safety, then it can be changed.
Is it law or policy?
It's law or it's law. That's how you can change it.
Okay. Who do I have next? Not trying to rush you out, Steve.
I think we got Jenna James.
Jenna James.
Good morning, Jenna James, representing Deep Well Ranch. I did have a presentation for you, but Stephen, I'm going to go ahead and skip to the end of my comments so that I can stay under that 3 minutes. I'm here today to ask that you make a no recommendation to council as it pertains to the proposed AVO, and the reasons are as follows. Number one is the development agreement section 2.6. The city will not initiate any changes or modifications to the master plan except at the request of or with the consent of the owners. And I reiterate that the city does not have the consent of James Deep Well Ranch. Section 2.7, no dedications or exactions. Except for the dedications and requirements identified in the governing requirements, the city agrees that it shall not attempt to acquire or require through zoning, subdivision stipulations, site plan approvals, or stipulations or otherwise, any requirements, reservations, conditions, or further dedications or portions of the property, or easements or other rights over portions of the property, or money or other things of value in lieu of those exactions. I contend that the AVO should never have been brought forth to this commission in such an unfinished state. The drafts are constantly changing, and there are outstanding land use issues surrounding the airport that should have been completed before this item ever came to this body for consideration, including pending appraisals we've been told will not be ready for another 4 months. The first presentation on this topic began on July 19th, but the noise contours that the airport director states are critical to this endeavor, and which the entire AVO is predicated upon, were not ready until October. So we've been considering this without the full set of facts for months. All of these unresolved issues should have been negotiated and resolved before the AVO was ever brought to you for your consideration. This commission is being asked by city staff to consider things that are also outside the scope of your duties. You're being asked to validate whether or not the projected 2026 noise contours are accurate. Noise contours that were completed by a firm that is the only firm in the nation who does this type of work using proprietary software, and you, as lay people, are being asked to confirm that those are valid by incorporating them into the land use code. This commission is also being asked to make a recommendation to council that they breach an existing contract in order to secure funds for future airport expansion. Lastly, this commission is being asked by city staff to be party to a condemnation action, and I don't believe that's what you signed up for when you agreed to serve on this commission. The AVO should not be recommended to council for consideration. At a bare minimum, it should only be recommended to council with the condition that the entire Deepwell Ranch master plan be exempted. Thank you.
Thank you.
Jonathan Millett.
I'll keep it short. YRMC objects to all four options that have been proposed by the city. Attorneys are officers of the court, and what that effectively means is you need to tell the truth when you're presenting your case. So I liken to it as like a photographer. You try to pick the best frame for your picture. And I think everybody understands the value of a reputation. When we break our promises, we lose that reputation and gain a different one that we really usually don't want. It's really hard to rebuild that. And as a counterfactual, if YRMC broke its promises under the development agreement, say started building a resort near the airport, I'm sure the city would be very upset and would probably bring in action to stop that. And yet that's what the city is doing here. It's breaking its promises that it made to YRMC. And it's expecting that YRMC will do nothing about it. YRMC promised to build a hospital and medical related uses, and it's still committed to doing that. This AVO, however, will make it very difficult to do that. In essence, it's taking 20% of the property away for about half of the uses. So the city had a couple options when it proposed the ordinance. It could have said, we're going to do this prospectively, which means future, not property owners, but future, future uses that have not begun. So there's no development agreement. There's nothing actually in place. This will be applicable to it. That's not what the city did. They chose to make it applicable to all the current property. And they're not exempting the current existing development agreements. So we'd ask you to help the city keep its promises by recommending, if you do recommend this for consideration to the council, an option that honors all the existing promises that the city's made. That includes under the development agreements, but I would say it also includes the current homeowners and the churches. It's possible to balance safety with the actual concerns that the airport has of noise, but you have to work within the current existing situation. Trying to impose because it's possible is not a good option. Thank you.
Thank you, sir.
Philip Shaw.
Mr. Chairman, Commissioners, good morning. I'm Philip Shaw. I'm the rector of St. Luke's Episcopal Church at 2000 Shepherd's Lane. We seem to have fallen upon a bit of a theme here, suggesting that you vote no on this proposal. I'll go along with that. But I would like to focus on one thing that has not been brought up specifically yet, and that is the justification for the hold harmless agreement that is part of the AVO. Before I became a priest, right out of high school, I was an English major. So I'm pretty good with reading and understanding English. For 25 years after college, I got a master's degree and I practiced land use planning. So I speak planning pretty well too. And when I read this, The grantors do hereby fully waive, remise, and release any right or cause of action which they may now have or which they may have in the future against the grantee due to any and all effects that may be caused or may have been caused by the operation of aircraft landing at or taking off from or operating at or on said airport. That's English. And it says the city and the airport are not responsible for damage to our church. That's a hold harmless agreement. I would like to know the justification for it. We have worked with the city on that site for 22 years. We proceeded with the city's present and future development approvals in good faith. We request that St. Luke's not be subject to any additional easement, hold harmless agreement, or restrictive use of our property now or in the future, because that was the commitment made to us. Otherwise, we believe the city of Prescott will be liable for payment of compensation for what would constitute an unconstitutional taking of our property rights. Thank you.
Thank you, sir.
C. Garthwaite.
Hello. Hi. Good morning, everyone. Thank you for the opportunity to speak today. I'll make it really quick. I have a few things from the last meeting of October 13th that I need to address. You should also know. Ms. Zabata said, and I quote, "So you want to put the poor people at the end of the runway in crash zones?" She said, and I quote, "I think we should put the poor people somewhere else." We are not poor people who live by the airport. Our neighbors in Saddlewood and Westwood live in new homes that are $450,000 to over $800,000. To refer to us as poor people because we live by the airport, it's not right. Another half-truth by Ms. Zabata. Number one, Embry-Riddle is in fact a for-profit institution. Please know this. I looked it up in AZ. To receive nonprofit status, the institution must put all profits back into their own pockets of the university. That is what they do. That is how they got nonprofit. They are not a charitable organization. This includes higher salaries and bonuses. That is what they do. The state of Arizona does not allow Embry-Riddle tax-exempt status as a nonprofit. Embry-Riddle has a net asset value of over $800 million. They can afford their own runway. Just because you remove the words non-conforming lots to a choice of 3 choices does not change the language. There are still oppressive restrictions on building with this AVO. Do not forget that. They will try and send you another dog and pony show. Do not fall for it. Mayor Phil Good in 2017 was the only councilman to vote no on the Deep Well Ranch Land Development Agreement. Did you all know that? I don't think you did. One can deduce that Ms. Zabata and Mr. Good are proposing this AVO to invalidate the 2017 legal contract with the city. I do not believe that they are working for all of our citizens' benefit, spending time and money on PR firms and consultants in promoting their personal agenda for the airport. They are spending our tax dollars knowing that this is illegal. To waste our tax money in this AVO with all of this and pushing their personal agenda, you are allowing this egregious violation of our trust. Commissioner Gambogi, you said you wanted facts. These are it. I have 3.
30 minutes.
Number 1, this AVO is not required by the FAA. Our airport is safe and protected already. It is not required for protection. It is not required to receive further funding. Number 2, it is illegal to break a land development agreement by the state statutes. Number 3, without consent, and you do not have consent. Number 3, the council meeting of Tuesday, October 21st confirmed the necessity of securing land for the development of future housing, schools, hospitals, fire, and police departments. These are critical to the health of I'm almost through, of development of our city. The only area where growth is possible is in the North Prescott area, Deep Well Ranch. They are very generous in allowing us to build and protect our city with future growth. And if you do this, it would eliminate any growth the city of Prescott. Once you do this, you cannot undo it. Thank you for your time.
Thank you.
Okay, that's all the comment cards I had. Tammy, do you have anyone on Zoom?
And
Do not have any
go ahead, Tammy.
hands raised at this time.
All right. And our 30 minutes are up. The timing worked out well on that. Appreciate that. Now going to open it up for commission members to make comments, and Ted asked to be first.
Thank you, Mr. Chair. I'd like to ask the question of the airport manager. Do we have that slide, George?
Which slide? Which slide would you like?
The one on the options?
Okay.
At our previous meeting, we were presented with a number of options that I wasn't quite clear with. So I asked to have those options listed in a iterative or progressive manner. And so I'm going to ask the airport manager to explain the 4 options that we're going to view today and consider.
Thank you, Commissioner Gambogi. Hi, I'm Robin Sabata, Airport Director. Good to see you all again. So what this did is we identified the 3 options that were listed last week, and we referred to the original option as option number 4. Just to refresh, I'm going to go ahead and just go back just quickly. Option 1, as it was presented, was basically focused on the 60 DNL noise contour, and impact zones 1 through 5 were protected. This map shows the black line for the original option 1. It's considered the least protective and least restrictive option. So on the chart that you're seeing, it's option column right here, number 1, showing residential permitted in this zone, residential permitted outside of this contour, Deep Well Ranch potential exception associated with this asterisk in this line, sensitive uses by category, hospital, YMRC North in this line, sensitive use hotel, motel, correctional facility in this line, sensitive use large gathering, library, daycare, social club, places of worship, RV park, convention center in this line. And again, another potential exception associated with option 3 for Deep Well Ranch Zone 3, which is, we refer to it as the south skirt. And that would be for mixed use hotel, RV parking. So this goes from least restrictive being lighter in color, most restrictive being darker in color. So you can kind of see the range of options. Other elements in every single proposal would be non-conforming use language is removed, abrogation easement required, fair notice disclosure is required. And I do want to point out on the abrogation easement, the easement that was referred to earlier actually has been in existence since 2002. That requirement is in the current code. It's not new. The version of the easement document has evolved some over the time, and actually there is a little bit more language that does allow suit for a plane falling from the sky or something like that in the newest version that our city attorney can go over with you if you'd like. Airspace protection for the FAA base evaluation and the airline 1 engine departure in every option, as well as contours, all stopping at the impact zone edge. Clearly, the impact zones are safety first, and that is what is associated with these plans. When you look at each of these options here, you'll note that what is the most closely aligned with plan, none of these were made up out of the air. All of these were identified as being associated with either the voter-approved general plan, the airport-specific area plan, or the 2008 land use plan and the airport master plan. So the reference documents as the basis for each of these options are all listed down here and identified. So as a refresher, there's option 1 that was just mentioned with a map. This is option 2, the moderately protective, sort of one of the middle options, and you can see the black line outside shows the future 60 DNL contour. Option number 3 offers the Deepwell Ranch option, and you can kind of see the line for the 65 DNL here would be the edge of the Deepwell Ranch if that were to be the option that were to be selected. 65 would be the outer edge of that contour, and through the rest of the AVO, it would be the future 60. And option 4 is it's not a new option, we just gave it a number. This was the original AVO option that was presented to you in the initial phase. And again, to be noted, even though the 55 DNL does protrude beyond the impact zones, there is absolutely no land use limit associated with anything outside of the impact zone. Again, safety first. So you can refer back to those maps during today's discussions if you'd like to. This is a comparison of the residential use versus industrial use that would be in each of the rings, the 65 ring, the 60 ring, and the 55 ring. Purple is industrial, and the yellow is the current possibility for residential in each of those. So if you have any questions on those, I'm happy to discuss them with you. But essentially, you can see the options all presented in a nice format that you had requested. None of the options have changed between last time and this time. It's just we gave a number to option number 4 so you could refer to it instead of referring to it as the original or the 55 version.
Okay, just as a review, the options in terms of how strict they are least strict at 1 and most strict at 4.
Generally, although you can see some darkness and lightness where there's, like, for example.
At the beginning of all this, we talked about 55, and throughout town, people talked to me about 55. So the 55 option is only in option 4.
That's correct.
Thank you.
Questions for Robin?
How about comments?
Questions right now. I have a quick question, Robin. I'm looking through here, and you're saying like option 1 is least restrictive and more restrictive as you go toward 4.
Generally, yes, with some exceptions. You can see wherever it's lighter, it means it's less restrictive.
All right, I just want to make sure on that part there. If no questions, comments. Tom?
Yeah. I'm concerned about all these options because there's an affordability question in front of us. And that, without that information, without our finance minister here telling us what the city can afford, because it's going to cost money. So without that information, I don't know how we can consider options.
I think that's a valid point, and thank you, Joseph Young, City Attorney. And at the beginning of this process, you are land use. You make recommendations on land use, not on contract. And so we had told you there are pre-existing contracts. There are things we have to take into consideration, and the council will do so. But you can feel free, and we don't want to step on your toes in terms of your discretion. So that's why last meeting we said you have the whole range of options, including recommending that areas where there's development agreements not be part of it. And that can be part of your recommendation. But the development agreements, and there's at least 3 of them, they do present some pre-existing rights. And that's what we told you kind of from the very beginning. And that's why when we've talked about takings without compensation, we understand that we can't do that. So if, to the extent that any land use regulation is a taking, we do have to pay for that condemnation. That's what you're bringing up. So at this point, as I mentioned, we don't want to step on your toes in your discretion. You can make those recommendations that where there's a pre-existing development agreement, that they be excluded, or you can make recommendations that are the most or the least restrictive possible. And so this is what you have before you. You're a land use recommending body, not a contract recommending body. And how you see fit to recommend this to council is up to you at this point. But we, as I've said, willing to answer these questions and discuss those. As it relates to kind of the idea of breach of contract, there is that consideration, but there's also the consideration in the contract that the condemnation is contemplated within the development agreement if it's for the purposes of safety. And so you have to determine in some ways whether something's essential to safety or not essential to safety. And that's what you're there to discuss. I would say the only other two issues related to that are the idea of the reduction in value and the requirement for an easement that are part of the AVO. The reduction in value as to individual homeowners, and there's a difference of opinion, but it's the opinion of staff that the reduction should not be, or should be minimal or non-existent, because uses
Please.
can.
All right, who's doing boo? If you do it again, I will ask you to leave. I'm serious about this. We will have decorum in this meeting. Is there any question on that? All right, thank you.
And
Joe?
let me just explain why I say that. The original drafts had the language about non-conforming uses. And so a house could stay a house, but it would be what we call grandfathered in or a non-conforming use. And that has a lot of restrictions involved, including inability to rebuild. If there was some sort of destruction of the house, they wouldn't be able to, if they couldn't rebuild within a year, they could never rebuild after that. There could be no expansion of the house. And so all of that has changed when we removed those uses from being non-conforming and just allowed pre-existing uses to continue to expand, and that would apply to churches and everything else. The other issue is the easement issue, which has been pointed out, has been in effect since 2002. It has been updated to, there is still hold harmless language, although it's liability waiver for normal operations of the airport. And so a plane falling from the sky is not a normal operation of the airport, which would then, the waiver wouldn't apply to that. So we're free to, as I said, I don't want to take away your discretion. We want to be clear with that. When we make our recommendations and answer questions, it's to help assist in answering questions, not to guide you in where you're to go, and that's your discretion. We also have, if you have questions regarding FAA-specific information, Eric Pilsk from Kaplan, Kirsch, and Rockwell, an aviation-specific attorney, is on Zoom if you have questions related to that. So thank you.
Joseph, I got a question for you.
Yeah.
This is our fourth planning meeting, and we've had 4 open houses. We seem to be inundated with questions of money and legal. But to your point, we're here for land use. Money and legal are not in our wheelhouse.
Right.
So is it fair to say that our decision is to move forward based on land use and leave the money and legal to the city council and our legal staff?
Yeah, particularly money as it relates to contractual issues.
Okay.
Because there's a lot of those considerations, and council's been updated on that, and we'll have to make those decisions. But fortunately for you, you're not a contract-making body. You're a land use recommending body. And that's why the idea of the least restrictive means of protecting the airport is something that should be important to you. And then to the extent that, as I mentioned, that you want to carve exceptions or recommend carving exceptions, because ultimately all of those decisions are made by the council, is something that's left to your discretion today.
Thank you.
Joe, I heard what you said about separating land use and the fiduciary responsibilities and all that stuff. But I don't know how you can separate that. I just don't see how.
And I don't think you want to outside of where there's development agreements.
But each one of those options has a different price tag, correct?
As it relates to development agreements, yes,
Yes.
it does.
So we're going to make a recommendation to the council, some kind of a recommendation, that's denominated in money.
And that can be part of your recommendation, that more or less of land is condemned or not condemned, whatever you see fit.
So how much does it cost to make everybody whole in option 1? All the people out there whole. How much for number 2? And that's outside of our view.
And I will say that as we relate to development agreements and open areas of land, that's where you're talking about condemnation. And I know I'm going to say something that probably nobody here wants to hear, but as it relates to individual homeowners, being that their use isn't restricted, we're not looking at the condemnation for those individual homeowners.
To their whole.
Under the law, they're whole. You might, and you're free to listen to their comments of why they don't feel they're whole, and I think that's a relevant consideration.
And we have.
Right. But yes.
Any other questions for Joe? Any other discussions to be brought up?
Yes.
Tom?
And this whole thing's a wreck. I mean, there's no question about it. This thing is a wreck. It's a train wreck. It's a train wreck in progress. And I would like to move that we table LDC 22-001 until such time as the land use decisions have been cleared up. Seconded if you want.
Tom, what do you mean by land use decisions?
The whole gamut of
Fill
this
that
thing,
in
I mean,
for
this whole thing is about land use. You're changing zoning, you're going to be changing the land use in that area.
Yeah?
You know, there are a number of land use decisions regarding existing land uses and how they're going to be impacted that are unresolved. Until such time as those are resolved, I would move that we table this whole deal. I don't see how you can put anything forward.
We have a motion. Is there a second?
I'm going to second it. This is Stan Galagowski. And here's why. Can I state it all or not?
Yes. Yes, you can make a statement.
So as Thomas said, what we've seen is this has really been a moving target. We've seen that, I kind of refer to this as a plane being built in flight. We see information that we're receiving information during the course of several months of this that has been brought to the light. We know that there are meetings occurring. We know we've been told that there's going to be meetings with the residents in these housing communities. There's just I have firmly felt that this document is not ripe. It's not ready for even public presentation right now. So I'm glad that we brought this to light. I'm glad that we've had a lot of community involvement in this, and that has been key. You could see the anguish on the homeowners' faces. And there's exemptions in certain areas, exemptions in other areas. And I don't think that we can make concessions with a document and it really kind of goes to show that the document doesn't show what should be allowed and what shouldn't be allowed. We're just not ready for this, and that's why I'm seconding it.
Okay. We have a motion and a second. George?
May I ask just for a clarification? I apologize for my voice. I've been sick. We've given you all copies of the actual AVO language that's proposed, the text of the document. If this motion were to pass and you table it, what would help us the most is for you to provide us written comments back on that. You've been listening a lot, but we haven't been hearing much from you specifically about what needs to be changed. And should you feel this appropriate to table today, that's the one thing that can get us back on track so that you have a document you can work with. That would be the most helpful for us. And with that, I'm going to rest my voice.
Do you want to?
I want to respond to that.
Go ahead.
You know, as far as asking us to make changes, that's almost ridiculous. I think that the change, there is no change. I mean, you'd have to have something in place that is decided before you can change something. There's no change that needs to be done here. You just need to do your work. The work that needs to be done with all the different users in this area. It's hard work, it's tedious work, but it's necessary work. And that is what appointed and elected officials are supposed to be doing. And I just don't see that being done. I don't see the work being done. I see that we get something different just about every time we meet. We get more information, less information, conflicting information. And frankly, I just think everybody needs to get out there and do their job. And this needs to be tabled until that's done.
Any other comments?
Yeah, I'd like to recommend that these, the work that Tom's talking about, avoid litigation, number one.
That ain't gonna happen.
And number two, proceed in a manner that's trusting and respectful to everybody involved.
Of course.
Ed?
I think it's important for the community to understand that we have an airport. The city has decided that we're going to maintain the airport. And the motions that you've seen, or the options that you've seen, are designed to do just that. Unlike what Mr. Polk said, the 2015 plan did protect the airport, and the 2017 contract changed that. Now, unlike Commissioner Goligoski, I don't think this is an airplane being built in flight. What they've done, what the airport I think has done, is come out with their best case scenario. And on the bottom of that slide that you're looking at that's behind me, you can see what I call the concessions from the original to where we are today. And that was designed based on the input from the attorneys, input from the citizens. So I think this has been good faith negotiation. I also think it's time that we move this on to the city council. We can't rule on money, and we can't rule on legal issues. We can rule on land use. So I wanted to make that clear for everybody here that this has been a good faith negotiation, and I think you've seen that list of compromises, and I want to set that record straight. Thank you.
Susan, did you want to make a comment?
Yes. I also have concerns about these plans. I agree that with some of the members that it's very difficult for me to separate the legal and the financial issues from this. To me, it's part of it. By the same token, I also am concerned about protecting the airport and protecting citizens coming into our community from being in impact zones and being irritated by noise. And several of the people that spoke from Saddlewood expressed issues with the noise. And I think that's part of what the airport is trying to eliminate in the future is having more people moving into the area that are going to be upset by the noise factors. So there's points on both sides. However, I'm also concerned with all of the moving points and the legal issues and some of the financial issues. So,
Thank you. If no other discussion, Kaylee, we call the roll for vote.
Yes, and I'm gonna state the motion as I understand it, and please correct me if I'm wrong. Commissioner Riley moved to table the public hearing for LDC 22-001 to such a date where more land use decisions are resolved.
With the outstanding land use decisions,
Where
the outstanding land use decisions are unresolved until they're resolved.
Okay. Where the outstanding land use decisions are resolved. Seconded by Commissioner Goligoski.
And is that Commissioner Goligoski's understanding of the motion?
Yes, it is.
Okay, I will take the vote. Stan Goligoski,
Yes.
Susan Graham,
yes.
Thomas Hutchison,
Yes.
Butch Tracy,
Yes.
Tom Riley,
Yes.
Ted Gambogi,
No.
Don Michaelman,
I vote no, too, and I'll give you my reason why. We should have resolved about the airport 10, 15 years ago. We keep kicking the can down the road. We were working here to try to come up with an option on it. And this is the reason I'm voting no, because I don't want to continue kicking this down the road.
okay. Motion passes 5-2.
Anything else from staff? If not, the meeting's adjourned.